Are you stuck in a family law issue and want to get to a solution? Are you trying to figure out whether you should go with litigation or mediation to help you with your issue? Don't worry. In this video, we will compare 13 different aspects for both litigation and mediation so that you are better able to make a decision. So without further ado, let us begin. 1. Nature of interaction. In litigation cases, each party is seeking to make their case against the other in a contest to be successful in achieving what they want from a judge. In mediation, both parties work with a neutral mediator to reach a mutually agreed-upon decision. 2. Range of application. Litigation can deal with any family law dispute. Mediation, however, might not be appropriate in some cases, like those that involve family violence or control, criminal activity, addictions issues, mental health matters, or areas of intensely high conflict. 3. Counsel. Parties in litigation may engage a lawyer right from the start. In mediation, this is less common, since both parties generally take a hands-on approach and consult with a lawyer only at the end to make sure all aspects of law are considered. 4. Time frame. Litigation is a lengthy process. It can take months and even years to complete. Mediation cases can be wrapped up in a matter of weeks and months. 5. Disclosure. In litigation cases, a number of specified documents are exchanged, and parties can demand documents as per their requirements, with both having to comply. Mediation generally involves a much quicker and consensual exchange of documents to the satisfaction of each party. 6. Interim issues. In litigation, a court application or negotiation can lead to a court order, which is used to solve immediate and interim issues. With mediation, such issues can be dealt with by a mutual agreement with the help of a mediator. 7. Evidence. Evidence in litigation matters is sworn under oath and can be used throughout the proceedings, whereas parties in mediation agree to provide evidence typically on a without prejudice basis. This means that the evidence cannot be brought up in other contexts, such as court, unless otherwise agreed. This allows the parties to communicate more freely. 8. Rules of evidence. There are clear rules in litigation defining what can and cannot be considered evidence. In mediation, there are no such rules, with documentation being relied upon when both parties consider it acceptable. 9. Issues. Litigation is strictly limited to legal issues, whereas mediation can deal with a larger variety of disputes and issues. 10. Conclusion. Litigation is about seeking resolution through a final court order or judgment which can be enforced by the court. Mediation, because of its very nature, comes to a conclusion when both parties agree on a solution in consultation with a mediator, which can then be made into a court order or agreement. At times, mediation may also result in no solution. 11. Future conflict. Future conflicts after litigation may require even more litigation at a future date, whereas in mediation, the agreements can have a built-in process to deal with future conflicts. 12. Costs. Litigation can be painfully expensive, with both parties unable to predict or contain the total costs. Costs can often go into the tens of thousands. With mediation, costs can be more predictable and controlled, with both parties agreeing on what they are willing to spend. And finally, 13. Consent. Litigation does not require mutual consent. Any one party can start the process independently. With mediation, both parties must consent to the process. We know that this can be a lot to take in. To review, let's look at some general positives and negatives for each of these processes. Positives. Litigation. Litigation is a well-known process, and when you obtain a court order, you can be sure that it is enforceable by the court. Moreover, litigation can deal with all types of matters and is quite thorough. Positives. Mediation. Mediation, being a flexible and collaborative approach free of strict procedures, allows for greater creativity in the problem solving. Not only can it be easier on the wallet, it can also ease tensions between the two parties. Above all, mediation can be considerably faster than litigation. Negatives. Litigation. Litigation is a rigid process which takes away some of the options for communication the parties might otherwise have. It also limits the range of outcomes which can be explored, which can lead to continued tensions between parties long after litigation ends. Above all, it can drain away a lot of time and money for all involved. Negatives. Mediation. Success in mediation, with the increased freedom and flexibility, can depend to a large degree on the skill of the mediator and the process they are using. In addition, if the parties do not come to an agreement, no one can force final resolution, and so the parties may end up in court anyway. This brings this video to an end. We hope you are now armed with all the information about litigation and mediation and feel confident that you can make the right decision for yourself. If you still have more queries, do not hesitate to contact us at Caliu Law. We are always available to help you out.